In the previous section, we examined how deeds transfer property during a person's lifetime. Now we turn to what happens when ownership must be transferred after death, through a legal document called a will. Understanding wills is essential for real estate professionals because these instruments often determine who inherits a property and how title is conveyed after a person passes away. A will, formerly known as a last will and testament, is a written legal instrument that directs how a person's real and personal property should be distributed upon death. The person who creates the will is called the testator, or devisor if referring to real property. The individuals who receive property through a will are known as heirs or devises, and the property transferred is called a devise. The will allows the testator to decide who receives their assets, rather than leaving that decision to state law. A will takes effect only after the testator's death and can be changed or revoked at any time during the testator's lifetime. In this sense, it is called an amendatory instrument. The testator typically appoints an executor, also called a personal representative, to manage the estate, pay any debts, and distribute the property according to the will. If the estate includes minor children, the will may name a guardian to handle their legal and financial affairs. Types of wills. There are several types of wills, each with specific legal characteristics. A witnessed will is the most common. It is in writing, signed by the testator, and witnessed by at least two individuals who are not beneficiaries. A holographic will is handwritten by the testator, dated and signed but not witnessed. Arizona recognizes holographic wills as valid even without witnesses, as long as the handwriting and signature can be verified. A codicil is an amendment or supplement to an existing will. It allows a person to make changes without creating an entirely new document, but must be executed with the same legal formalities as a will. An approved will is written on pre-printed forms that meet the legal standards set by state law. A nuncupative will is an oral will made by someone near death. Arizona does not recognize nuncupative wills as valid. In everyday terms, a will can range from a simple written statement of wishes to a highly detailed legal document with multiple provisions. The key is that it must clearly express the testator's intent and comply with state law to be enforceable. Requirements for a valid will. For a will to be legally valid in Arizona, several conditions must be met. The testator must be mentally competent and of legal age. The will must be in writing, signed by the testator, and executed voluntarily without coercion or duress. The document must clearly state that it is intended to serve as the testator's last will and testament, and it must be witnessed by at least two people who are not named as beneficiaries. Different terms describe how property is transferred through a will. A devise refers to the transfer of real property. A bequest refers to the transfer of personal property. A legacy refers to the transfer of money. Probate, the legal process of transferring title. The legal procedure for validating a will and settling an estate is known as probate. Probate ensures that the decedent's debts are paid, that the will is valid, and that remaining property is distributed to rightful heirs or devisees. If someone dies testate with a valid will, the probate court will follow the will's instructions. If the person dies intestate without a valid will, the court distributes the property according to Arizona's laws of descent and distribution. Probate of real property occurs in the jurisdiction where the property is located, even if the decedent lived elsewhere. During probate, the executor, if named in the will, handles the estate's affairs. If no executor is named, the court appoints an administrator to serve that role. The primary purposes of probate are to confirm the validity of the will, identify and pay debts, taxes, and expenses, transfer remaining property to heirs or devisees. Probate can be time-consuming and costly, which is why some people use tools such as living trusts or beneficiary deeds to avoid it. However, probate provides a legal mechanism for transferring title that protects the rights of creditors and heirs. Types of probate proceedings. Testate proceedings. If the decedent left a valid will, the court first pays all legal debts and taxes, including property taxes, estate taxes, and inheritance taxes. The court also recognizes any existing legal life estates, such as homestead or elective share rights. After all claims are satisfied, the remaining property is transferred to the beneficiaries named in the will. Interstate proceedings with heirs. If the decedent dies without a will but has living heirs, Arizona's laws of descent determine who inherits and in what proportion. For example, if John dies intestate leaving a wife and 4 children, the wife might receive 1/3 of the estate while the children share the remaining 2/3 equally. Intestate proceedings with no heirs. If there are no legal heirs, the estate esquetes, meaning it reverts to the state or county after all debts are paid. Esquete ensures that no property remains ownerless. The practical importance of a will is not only a tool for transferring property, but also a clear communication of a person's final wishes. It can direct how funeral arrangements are handled, identify who will care for dependents, and specify how debts and taxes will be paid. For example, a testator may state that their home should be sold, with proceeds divided among children, or that a specific heir should inherit a piece of land that has been in the family for generations. Wills can take several practical forms. A simple will clearly states who receives what assets. A joint will is created by 2 individuals, typically spouses, where the surviving spouse inherits first and the remainder passes to others after the second death. A testamentary trust will creates a trust upon the testator's death, allowing a trustee to manage and distribute assets for beneficiaries such as minors. Each of these formats can simplify probate and ensure that the testator's intentions are carried out smoothly. Example in practice. Consider Maria, an Arizona homeowner. She writes a simple will leaving her home to her son, appoints her sister as executor, and specifies that any remaining funds should go toward her grandchildren's education. When Maria passes away, her sister files the will with the probate court. After debts and taxes are settled, the court transfers the home's title to Maria's son. Because the will met all state requirements, probate proceeds efficiently, and Maria's property is transferred according to her wishes. If Maria had died without a will, Arizona's laws of descent would dictate who inherits her home, which might not align with her intentions. Review summary. A will is a legal document directing how a person's assets are distributed after death. It takes effect only upon the testator's passing and must meet formal legal requirements. Wills can be witnessed, holographic, or created through approved forms. Arizona does not recognize oral, non-cupative wills. The probate process validates the will, settles debts, and transfers ownership to heirs. If no will exists, the estate is divided according to state law. When no heirs exist, the property esquetes to the state. Wills offer peace of mind by ensuring that real and personal property are transferred according to the testator's wishes rather than default legal rules. Discussion. Why is it important for a will to meet state requirements? Answer. Because an invalid or improperly executed will can lead to disputes, delays, or an intestate proceeding where state law determines inheritance rather than the testator's intent. What is the main difference between a testate and intestate proceeding? Answer. A testate proceeding follows a valid will, while an intestate proceeding occurs when there is no valid will, and state law controls who inherits the property. Why does probate occur in the state where the real property is located? Answer. Because property law is governed by the jurisdiction in which the land lies, giving that state authority over its transfer and title. What is the role of the executor in probate? Answer. The executor carries out the testator's wishes, settles debts, pays taxes, and ensures the distribution of assets to rightful heirs or beneficiaries. Closing remarks. Understanding wills and probate is crucial for real estate professionals, as these legal processes directly impact property ownership and transfer after death. Whether assisting a client with an inherited home, explaining probate sales, or navigating a title issue arising from an estate, a clear grasp of how wills operate ensures smoother transactions and better protection for all parties involved.